It's nearly been a year since the introduction of the GDPR. Was it all a storm in a teacup? Has it been an easy transition?
Well, I would say GDPR, yes, it's nearly 1 year now from the 25th of May, and what I can say is that a lot of lessons have been learned. There was a good amount of it which was a storm in a teacup, I think, in the sense of a lot of emphasis being put on the potential fines, the panic leading up to the 25th of May, which was perhaps unnecessary. However, on the other hand, I think this year has taught us a lot of lessons, and we've experienced it with clients and also ourselves as an organization, that there is a really good need to look at the detail of what you do with personal data from beginning to end. And I think a lot of organizations were underestimating how complicated and how complex things can get. Until then, you start putting things in order, because once you get a snapshot of what you're doing, how you're using that personal data, what you're trying to achieve with it, and how you can make better use of it, then once you do that, then compliance becomes much easier. But the first headache has been, for a lot of organizations, of trying to achieve that first hurdle, getting that snapshot. Now, we're trying to, get used to the terms of GDPR in a more practical sense. So when one reads this regulation, because effectively it is a regulation, and reads it also in line with local legislation on data protection, the next question is, how do I start implementing this in practice? It's very easy to say there are 6 principles and there are 6 grounds and more grounds if you have special category data, but then how do I implement in practice? And I think what we've learned and what our clients are learning, and we have to continue to learn, is how to translate something which is very subjective, a subjective piece of legislation, into something practical. There is a lot of risk-based assessment that has to be carried out. There is no one-size-fits-all solution, and this is what we're learning to do. And the more we learn about our experiences, the more we share experiences with clients and learn from judgments of the courts, decisions of the industrial tribunal, of the data protection commissioner, the more we can do things better. And I think GDPR will become more of a reality in the way we do things on a day-to-day business perspective.
A lot has been said about Doreen Cammalleri versus the Information and Data Protection Commissioner. Is it correct to say that an employer cannot access emails of a former employee?
A lot was written about this particular case, and perhaps some of it was not exactly correct or gave the wrong interpretation. What it was about was a former employee complaining about the continued use by her previous employer of an email account which had her name and surname in the address, and also obviously contained content which included her name and surname. The claim she made was not that an employer cannot have access to the email account of a former employee. It was never her claim, and neither was her claim one which requested the court to stop the access based on the fact that there was her name and surname. What the court did actually confirm is the fact that a name and surname is personal data, and therefore data protection law has a play on how that former email or that former employee's email can or cannot be used by an employer. It studied the grounds provided by GDPR as to how and when an employer can process personal data. It looked at the obligations at the law and it discarded that. It looked at the considerations of public interest. This was a government agency, but set that aside as well, and focused on what we have always been advising, that effectively accessing and referring to former employee emails could be done on the ground of legitimate interest, so the interest of the employer to carry on with its business after an employee leaves the employment for whatever reason, with a focus, however, on 2 key considerations. One is that employees have to be told a priori as to how their emails will be accessed, to what extent they will be accessed once they leave their employment. And secondly, that it is done fairly and in a regulated manner, so that there wouldn't be arbitrary access to email accounts of former employees indefinitely or without any type of parameters or control, but within a regulated environment. So you need to know who is accessing, for what reason, and logs are taken of what is done in terms of the policy that you have in place.
Is there anything worth looking out for from a data protection perspective?
What I can say is data protection law now is becoming more exciting, because we're focusing for a long time on compliance, on getting compliant with GDPR and the rules and regulations that there are. But now we're starting with the litigious part of data protection law. So we know of clients and also other entities who are being investigated by the Information and Data Protection Commissioner. We know of entities that have received reprimands, have been warned to do things differently, and we know also of ongoing court cases. For instance, there is one very interesting case that we are involved in, which relates to an individual's image rights and the use by an employer of that person's image for employment-related documentation and marketing material that was created by an employer. And this individual has taken actions against the former employer to claim that her rights are being misused by the employer despite her having left employment. And the issue there is she correct, yes or no? Was there abuse, yes or no? And did she give the consent in the first place, yes or no? And if she is successful on that, we believe that this is the first claim of that nature, which is questioning the right to moral damages, which is regulated by GDPR. As we know, the concept of receiving compensation for a moral damage in Malta, very little applies of that in our legal system, and therefore this is testing not only the application of GDPR but also Maltese principles of law, and we have to see how Maltese courts will assess the level of moral damage, if any, that will be awarded to this individual.